Se verá. Yesterday, El Sur, Pueblo versus Texas. Oral argument would be this session, February 22nd, 2022, which is yesterday. Case number 20493, case number 207622.
We'll hear argument next in case 207622, Denez P. versus United States. Mr. Kimberly.
Thank you, Mr. Chief Justice, and may it please the Court. The Double Jeopardy Clause implicates two distinct exercises of sovereign authority. First, the authority to say what an offense is, and second, the authority to put an individual in jeopardy for committing an offense. This Court has consistently assumed the importance to the dual sovereignty doctrine of both expressions of sovereign power. The analysis thus asks not only whether the two law-giving entities draw their authority from separate sovereigns, but also whether the two law-enforcing entities do so. The government disagrees. It says that the separateness of the offense-defining entities is all that matters. But that position would invite the precise abuses that the Double Jeopardy Clause was intended to prevent. And the CFR courts themselves provide the evidence. Assault, for an example, is an offense under both tribal law and the BIA's regulatory criminal code. According to the government, if petitioner had gone to trial rather than taking a plea on the tribal offense and he had been acquitted, the very same prosecutor would have been free the very next day to bring a successive prosecution for a substantively identical offense, this time having honed his case and refined his proof based on the lessons learned in the first prosecution. That is not an outcome that the framers of the Double Jeopardy Clause would have thought tolerable. In arguing otherwise, the government focuses on a single word, offense, which it takes entirely in isolation and to which it applies rigid dictionary definitions. But the Bill of Rights prevents not only transgressions of the amendment's literal terms, but also governmental efforts to circumvent their protections. Blockberger itself embodies this anti-circumvention principle. It holds that technically different offenses, codified in different code sections, comprising different elements, nonetheless may constitute conceptually the same offense for double jeopardy purposes, when, for example, one is a lesser included of the other. And our position is that the same Blockberger
just so that I understand what you mean by we have to take the prosecution. So
we'll hear argument next in case 20. We'll hear argument.
Provide the evidence. Assault, for an example, is an offense under both tribal law and the BIA's regulatory criminal code. According to the government, if petitioner had gone to trial rather than taking a plea on the tribal offense and he had been acquitted, the very same prosecutor would have been free the very next day to bring a successive prosecution for a substantively identical offense, this time having honed his case and refined his proof based on the lessons learned in the first prosecution. That is not an outcome that the framers of the Double Jeopardy Clause would have thought tolerable. In arguing otherwise, the government focuses on a single word, offense, which it takes entirely in isolation and to which it applies rigid dictionary definitions. But the Bill of Rights prevents not only transgressions of the amendment's literal terms, but also governmental efforts to circumvent their protections. Blockberger itself embodies this anti-circumvention principle. It holds that technically different offenses, codified in different code sections, comprising different elements, nonetheless may constitute conceptually the the same offense for double jeopardy purposes, when, for example, one is a lesser included of the other. And our position is that the same Blockberger rule ought to apply anytime a single sovereign undertakes successive prosecutions, regardless whether separate sovereigns have defined the respective offenses. And I welcome the Court's questions.
Mr. Kimberly, just to so that I understand what you mean by we have to take the prosecution, the source of the prosecution into account. Let's say prior to trial, the tribe charges petitioner here. And on day one, on day two, the federal government charges petitioner. Are those two separate offenses with which he's being charged?
These are both charges in the CFR court?
One in CFR court, one in federal district court.
I think those are not the same offense, Your Honor, because it would be the tribe bringing the charge. I think what distinguishes this case...
No, that's not what I'm saying. The tribe, there's a charge under tribal law. That's charged for the same activity, just what we're talking about here. But before trial, the federal prosecutor charges under federal law, just as you have here, but there is no trial yet. Are those two separate offenses?
If I'm understanding Your Honor's hypothetical correctly, it's a tribe charging one offense. It's the federal government charging a federal...
Exact same charges we have here.
Before jeopardy has attached. It sounds to me like those are separate offenses to which the dual sovereignty doctrine would apply.
Okay, now what undoes that? If, let's say, after that, you reach you're tried in the CFR court, and we have what we have, the outcome we have here. Then you have a trial in federal court. What changes the fact that you have two separate offenses?
Well, I think, so there are two ways of answering this. I think the first way of answering this is to say that when the prosecuting entity the first time is a federal instrumentality that is relying on federal law to authorize a federal officer to prosecute a tribal offense in federal court, that is in effect the United States making the offense its own. After all, we need in the CFR court the operation of a federal law here. It's 11 CFR 11.108 to make the tribal offense enforceable by a federal officer in federal court. And that process, the court could say, in a sense, imbues the offense with, at least in part, a federal character. And that is distinct, I think, if I was understanding Your Honor's hypothetical, it's distinct from when a tribe in a tribal court pursues a prosecution for that same offense.
Thank you.
Is that your only difference? Going back to our decision in Wheeler, the court in Wheeler went through quite a number of ways in which the Navajo tribal court at issue was subject to ultimate federal control. And I want to know what you see as the difference between the federal control recognized by us in Wheeler and the federal control at issue here in CFR courts.
Well, I think the question in Wheeler, Your Honor, was just whether the tribes actually constitute separate sovereigns for purposes of the dual sovereignty doctrine. And so in undertaking that analysis, the court looked, as it later described it in Sanchez Valle, as the well springs of the authority that the tribe has both to define and punish crimes. The court acknowledged that there is congressional control over the tribes in certain actions that they can take, but that did not extinguish the core source of the authority that tribes have for defining and prosecuting offenses.
So tell me what distinguishes it here.
The question here is somewhat different. It's accepting that the tribes in the United States are separate sovereigns. It's who is bringing its sovereign, which of those two is bringing its sovereign authority to bear in prosecutions brought in the CFR courts. And our position is that it must be federal because the prosecutor in this case, the prosecutor in the Ute Mountain Ute Tribe CFR Court, is a federal officer answerable to federal authorities. He is not a tribal officer answerable to tribal authorities. He draws his authority in the CFR to prosecute, and the CFR Court draws its authority to punish from the Code of Federal Regulations and from the United States Code authorizing the promulgation of those regulations.
So would it have mattered if the tribe had contracted with the government to provide the prosecutor? The tribe had actually provided the prosecutor.
I think the answer may well be yes, Your Honor. If the tribe were furnishing the prosecutor such that the prosecutor was answerable to tribal authorities so that one could accurately say that the prosecutorial discretion being exercised, the decision what charges to bring, what penalties to seek, what leniency to grant, what plea deal to negotiate, were in fact expressions of tribal sovereignty and tribal authority, then I think the answer is we may well be in a different situation. But
so it'd be an easy fix if you were to win in this case. CFR courts could continue so long as the prosecutor was tribally controlled.
I think that's right, and I would say that I think there are two easy fixes, Your Honor, both of which are substantially more respectful of tribal sovereignty than what happened here. First, you could have a 638 contract that allows the tribe to control and bring the prosecutions. Beyond that, you could also just have the simple administrative fix of reallocating the resources for these CFR courts to grants to the tribes to establish their own judicial system.
There already are. These tribes are too small to make use of those grants.
Well, I think the
grants aren't big enough. They're not big enough in light of the poverty of the tribes.
Well, that's right, but so the suggestion is rather than the federal government spending money on CFR courts, the federal government can spend money to allow these tribes to band together the way that they do under the CFR courts already to create tribal judicial systems of their own. In either event, either of those fixes would be more respectful of tribal sovereignty than forcing tribes to accept the federal government's taking over of responsibility to bring prosecutions on behalf of the tribes, which necessarily federalizes the prosecutions because, again, the prosecutors are, in this case, and in the Ute Mountain Ute Tribe CFR Court, are answerable to federal authorities.
Mr. Kimberly, do you think, well, let me ask you this, why aren't you making the argument that the tribal crimes have been assimilated as federal crimes? Because if that were true, then you have two federal crimes and you're just looking at Blockberger, right, even under the government's theory. Do you think that would be a winning argument if you made it?
I think it would be a winning argument, Your Honor, and I think I would feel comfortable analogizing to the assimilation of state crimes under the Assimilative Crimes Act or the Major Crimes Act. I think what's a little different is here we know, for example, that petitioner was in fact charged with a violation of the Ute Mountain Ute Code. When an individual is charged under an assimilative crime under federal law, he or she is charged actually with the federal crime. Well,
so it's not assimilated. So you think it's not the same thing?
Well, I'm sorry. So to be clear, our position is that when a federal officer is exercising federal authority in a federal court to prosecute a criminal offense of another sovereign, it takes an exercise of federal legal power to do that. And again, we have that at 25 CFR 11.108. And that, in effect, does imbue for double jeopardy purposes the offense with a
But
federal.
I thought that you were making an enact and enforce argument. I didn't understand you to be disputing that this crime was a tribal crime. I understood you to be seeing a distinction between the regulatory crimes and the crimes that were crimes that came from the wellspring of the tribe's law. That is an important point to me, so I want to make sure I understand your position on it.
And so I'm not sure I understand.
Are you seeing a distinction between the federal regulatory crimes and the tribal crimes, or are you arguing that, say, 25 CFR 11.449 functionally assimilates the tribal crimes into federal law like the Assimilation Act does for some state crimes?
We're not making a formal assimilation argument. I think it would be perfectly acceptable if the court wants to take that approach, but our principal position is that it doesn't matter, and that for double jeopardy purposes, there's no meaningful distinction.
Well, it may not make a meaningful distinction here. I acknowledge that, but I do want to follow up on this question. And I don't want to revisit Gamble. I was in dissent there, and so I must have been wrong. But here, am I correct that the tribal crimes are only enforceable in CFR court with the assent of the Secretary of Interior?
That's exactly right, Your Honor, and that comes from, it's duplicative of 25 CFR 11.449. It's also 11.108, which is the provision that requires approval of the Senate.
And historically, as I understand it, that was an important feature of the law because the federal government, in its infinite wisdom, didn't want every tribal crime to be enforceable because they thought some of them were not sufficiently worthy or of federal respect. Is that right?
I think that's part of it. If I may supplement that answer, Your Honor, I think it's also because the BIA itself has always understood that the CFR courts and prosecutions taking place within them are fundamentally federal and therefore must be consistent with federal law, and therefore a review of tribal crimes to ensure consistency with federal requirements for the operation of federal instrumentalities were recognized.
Can a federal criminal statute include a racial classification?
It's a fair question, Your Honor. I think there is a serious constitutional equal protection question about whether or not that's the case.
So if we were to hold that this provision of the tribal code was really federal law, we would have to confront that question, wouldn't we?
Well, I think you've got to confront that. One, I should be clear, that isn't a question presented here. I think the court would have to confront that question perhaps in a future case, regardless, because there is a federal regulatory criminal code adopted by the BIA independent of tribal laws, and that too has the same racial classification as a precondition to its application.
And if I might return to what I think of as the Barkas exception argument that I take you to be making, that the court recognized that there are some instances where even if they are nominally separate sovereigns, they function hand in glove to the point where we will find double jeopardy violations to occur even if they are nominally pursued by separate sovereigns. And the federal government makes the argument here that the Barkas exception shouldn't apply because they didn't really get two bites at the apple here. That your client pled guilty and that therefore there's no real worry, double jeopardy concern that we should attach to this case. Can you respond to that argument?
Well,
We'll hear argument first this morning in Isleta del Pueblo versus Texas. Mr. Martin.
Mr. Chief Justice, and may it please the court. The question this case presents is whether the Restoration Act subjects the Pueblo to Texas's time, place, and manner restrictions as it relates to games that Texas does not flatly prohibit. It does not. In the Restoration Act, Congress codified the cabazon ban framework and specifically foreclosed Texas's regulatory authority over the tribe's gaming activities. The plain language of the act provides us with clear support for this interpretation. On the heels of this court's decision in cabazon, Congress changed the language of the Restoration Act to replicate the prohibitory regulatory dichotomy struck in cabazon. Section 107A incorporates the cabazon framework. It federalizes Texas law, but only as to prohibited games. And bingo in the state of Texas is not a prohibited game. Section 107B clearly forecloses any interpretation of Section 107 in its entirety where Texas would have regulatory jurisdiction over tribal gaming. And Section 107B must have meaning in the Act. The problem with the state of Texas's interpretation and the Fifth Circuit's interpretation in its later one is that it reads 107B out of the Act entirely. This interpretation is also consistent with Congress's extension of the cabazon framework to IGRA. The two statutes are not in conflict, and you don't have to choose one over the other. And even if that were the case, and we don't think it is, the plain language of the Restoration Act allows my client to engage in non-prohibited gaming activities. In Sections 107A and 107B, Congress was sending the clear signal that it was incorporating the prohibitory regulatory construct from cabazon into a test applicable to these tribes. The final text of the Restoration Act reflects the bargain that Congress struck. Each side got something, but not everything. Texas was allowed to prevent prohibited games from being played by these tribes. Meanwhile, the tribe was allowed to retain its sovereignty and its freedom from regulation as it related to gaming activities. And with that, I'd be pleased to answer any questions from the court.
Yes, counsel. The cabazon was a grant of jurisdiction, right?
Yes, Your Honor.
Is there any difference? Is there a grant of jurisdiction in 107A?